Everyone is compelled to share his or her personal data, medical history, or some other personal information at a hospital or medical facility at some point. There exists an obligation on medical establishments or personnel to keep such information private and not to share or disclose without some form of legal authority, justification, or consent. Stay with us as we take on the topic patient confidentiality. This is Law Express. My name is Noella Seidu. Don't go away.
Elizabeth Owusua is a private legal practitioner and a nurse. She enjoys reading, caring for patients, and watching movies. Dr. Edward Adodankwa is a private legal practitioner and a medical doctor with love for choral music, tennis, and movies. Noella Seidu. She's a private legal practitioner and a consistent member of our 3-lawyer panel on the show every week. She also doubles as the host of the show. She likes to play tennis and read.
Confidentiality is an important ethical consideration in healthcare. It is this duty to avoid disclosing information obtained from patients which are confidential, which are sensitive. A duty to prevent this from being disclosed to third parties, unintended third parties, or people without the consent of the patient. Confidentiality allows patients to trust us, to come to us, to open up. And by this, we are able to get the right information to aid diagnosis and accurate treatment.
Okay, to add to that, because you're already going into the why confidentiality is important, just to set the tone, it's a patient's right, first of all, to have his or her information kept confidential or private.
And then in our jurisdiction, privacy is guaranteed by the 1992 Constitution as well.
Yes.
And so an extension to that, we can talk about the patient's private information that has been given to you and also be termed as being guaranteed by the 1992 Constitution, and therefore it must be guided at all times. And then just as he was also saying, if the patients are able to know that we can keep their information private because it's sometimes or almost always very sensitive, which is about their person. And if we are able to keep it private, then they will be able to open up more whenever they get to the hospital, and we'll be able to give accurate treatment and for whatever ailment that they brought to the hospital.
When people talk about patient information, there's this notion that it's just medical records. But you and I know that when you get there, you fill in information about your history. You're looking at family, information, background information. You're looking at sometimes credit card numbers because you have to make payments there. You're looking at your name, your other biodata. You are likely to even bring an ID card in some instances. So it's not restricted to just medical information in the strict sense where it's about the condition you're suffering from, your lab results and stuff like that. Doc, earlier on you were talking about why confidentiality is important. You already mentioned trust. Probably we could explore that angle further.
Yes, confidentiality is very important. It's one of the cornerstones of Medicare. It enables them to open up, to tell us everything concerning what they are suffering or why they are there. Yeah. Some of this information can be very sensitive, and at times we keep all this on record. Sometimes we are looking at things the patient himself or herself has not even seen about the body before. At times we are touching places they themselves, their hands may not even be able to go. And all of these are done in the spirit of trust that as your physician or as the doctor, they can open all this up to you because of the help they are seeking. And truly, like you said earlier, we do go beyond the general medical staffs. We have social history, and we have gynecological history, abortion history, very sensitive information, religion, etc. All of these are put together in a certain context that aids with healthcare.
What are the instances? You are both in the medical field as well. Fortunately today, apart from my panelists being lawyers, they are also a doctor and a nurse. I think it's exciting because this will enrich our conversation. But I'm looking at the means or how mostly these lapses occur. Automatically, we have the nosy neighbor who comes to visit and is busily asking the nurse or sister on duty what really the problem is with the patient, for instance. How do you handle instances like that?
So for those instances, per our culture or how our community or society is formed, mostly somebody is sick, you just ask, somebody just tells you that, oh, I'm not feeling well. The first thing the person may ask, what's wrong with you? What are they saying is wrong with you? Yes. As if it's just something that we can just say about it. You are sick. What is wrong with you? Everybody wants to know. Some people bring people to the hospital, and the first thing after consultation and or what is wrong with the person? What are we treating the person for? Labs are done. What did the lab see? And all that. That is the practicality of the whole thing. But for our context, most of the time, I will say that if we are very much aggressive with dealing with confidentiality and or then a lot of health workers, health facilities will be in trouble because people they are of age, they are adults, and they are supposed to, what is supposed to be done is that the health personnel will inform the patient, then the patient in turn will have to inform the relative who wants to know. But most of the time, since they brought the person and maybe they fill the form, just as we talked about filling forms, and the person has put the name as the next of kin. Probably it was even a colleague from work, and the person felt ill at work, and they brought. But then the name on it and the contact number at that particular point is the next of kin, and everything is referred to that person. And that person gets the information which maybe under normal circumstances the patient won't have allowed the person to get. Practically, it may depend on whoever you meet at the health facility, how knowledgeable the person is about some of these things. Then from there, the person may be able to deal with it, either to disclose or not to disclose from there.
Just to add, we used to have the folder system, physical folders.
Yes.
And that was an era where we used to have a lot of these breaches. Sometimes the folder, a doctor will prescribe some medication, the folder is given to the patient or patient relative to take it to the pharmacy to go and collect drugs. I have an instance where a patient came, I was attending to a patient, a lady, and she indicated to me that the relatives around know or think she's pregnant. So I should not disclose her pregnancy status to any of them. And I did actually indicate that even in my notes, that nobody should disclose that. At times what we do is, when we look at the context and the circumstances of the particular patient, it will be in the interest of the patient not to do certain disclosures. If you do so, sometimes they will desert the patient. So
but who is disclosure supposed to be made to? Should it not be the patient?
The patient, him or herself. But just as I said, practically, sometimes it's difficult for that one to be done.
So if the person is in a coma and can't give any consent, or if the person is a minor?
For those practicalities, if somebody is in a coma, or that's why we have the next of kin. Yes. We have the legal guidance for the minors also. So for those circumstances, definitely it's somebody that is making decisions on behalf of that person.
I asked the question, Dr. Adil, because I want to understand why it has to take a patient to tell his doctor not to disclose his or his condition to family before that is done.
Yes, I'm sure that's a patient who wants to be extra cautious, because we are still aware practically that sometimes people are a bit nosy and are able to pick some information. In fact, in this example, At a point, a nurse gave the folder to the gentleman to go to the pharmacy for a drug. The gentleman came and told me that he has read the entire folder and has seen the pregnancy status of the lady. And truly, they deserted the lady. The lady was moody, very angry, and I knew what my people did were not right.
So
but
that's a
how
breach.
Devastating. That was a breach, clear breach. And it had a very devastating consequence on the way the treatment of the lady went. She was disappointed.
Naturally.
Naturally.
What about these nosy medical personnel who probably they don't even belong to that particular ward or wing, but would come because of familiarity, go from room to room, snoop through people's information?
It is unacceptable. It is unethical. Information disclosure is supposed to be within the circle of medical personnel, the team attending.
On a need-to-know basis.
On a need-to-know basis, the very specific team handling the patient. At times, it may go a step forward, maybe X-ray, somebody need to do something for the patient. They may see the history. The lab, they may see a bit of the history. But like you said, it's strictly on a need-to-know basis and should be restricted to only those who need really to know.
But when you look at the practicality of it, in a hospital, right from records, there are so many tiers or layers of personnel that have to handle patient records. So the person who is in charge of the OPD may get a few clues, all the way to the first attendant who is taking some, what do you call that? Vitals?
Vitals.
And then you move on to consulting, then pharmacy, and all of that. At what point do you know where a breach occurs?
So sometimes practically, just as I was saying, it may be difficult because you don't know who is picking up the information. And for hospital setups, although they are strictly health personnel there, there are non-health personnel also there.
Exactly, the cleaners are there, orderlies.
Now it's e-services that we use for information. But for a bit of protection, they usually give access to particular sessions, to particular workers. But for even that one, sometimes because the person will have to also work on some things, maybe administratively or account or from audit, they may have a bit of access to the patient's information, which to them, they don't think they hold the duty of confidentiality to the patient. So on a practical base, where I work, just behind the clinic, there's a kinky joint there that people from the clinic sometimes go there to go and eat. A colleague of mine came back and said that when she got there, it was there that people from account audits were discussing a patient's condition. They were at the kinky joint eating, and they were discussing somebody's condition right there.
These are non-medical personnel.
So when information goes out, then now the first thing that will come to the person's mind, should the person get to know about this, will be that it was the medical people that leaked the information or shared it to someone else. But from this one, it's a total different people, audit account departments that were able to share the information.
How did they get the information?
Just like I was saying, so it's the system, but then you are limited, there are limits to your access to the information, but you have some form of access to the information
by virtue
from
of
them.
Where you work. Let's look at how much information a doctor should tell a patient about his or her own condition. Well, let's say medical personnel shortage. The ratio is ridiculous. And because of the pressure, historically, we've had doctors try to move faster, such that there's no time to now sit with you, to hold your hand, explain what is happening, and answer all questions. This is still about confidentiality, but it concerns the actual patient. How much of a patient's information or health condition should the doctor divulge, and what are the restrictions to that disclosure?
That is true. That has historically been the situation, but at times it's been for good reason. Going back a bit, Clever had indicated that we should try and give hope to patients. So in those era, we didn't have treatments or medications for a lot of the ailments that afflicted people. So you do not hit a patient hard with terminal news that may sometimes even worsen their emotions and probably even fast track their death. So at that time, what they used to do most was withholding some information they thought could be detrimental to the patient and then disclosing what they thought was necessary. Gradually, we have moved away from that, and it's been suggested that you should be truthful as much as the patient can contain.
How do you know what a patient can contain?
You look at the condition of the patient. In the first place, now we have treatment for a lot of the ailments. If today somebody has TB or malaria, there's no need for a doctor giving hope per se. It's about counseling for them to adhere to treatments because the treatments are there and they can therefore handle that. But where a person is having some form of a cancer, therefore there's a need to be a bit careful, a bit empathic to how information is disclosed. But you should not lie to a patient should they ask for disclosures. What we do, and I'm glad you phrased this, the current case of Montgomery, initially there were this difficulty as to what risk should be revealed to a patient. Some countries said when the risk has a possibility of about 1% occurring, should be disclosed. In an Australian case, they indicated 5%. Later, a Canadian case said 10%. We came back to England and it was different. So with Montgomery, he said whatever information that is material should be disclosed.
Okay.
Then how do you identify what is material? What is material is what a patient in the shoes of this particular patient will consider necessary, or what a doctor reasonably acting in this particular patient's stead will also think is necessary. So we have those arms to guide what should be disclosed to a patient. But at all costs, a doctor should not lie to a patient who has asked to be told the information about the patient's condition.
From experience, have there been instances where frank discussions about people's terminal status have rather made them die sooner?
From experience, not made them die sooner, rather. But then I remember a situation where there was a terminal ill patient at that place, and then the doctor did family counseling for them and said, well, the prognosis is guarded, and therefore they should put their house in order and all. The next 2 or 3 days, we came back, and now the man was sitting up, eating on his own and all that. And then the doctor was like, hey, then this family will say that I was trying to kill their patients. Because from a cultural side, nobody wants to hear about death. Nobody wants to hear that whatever that is wrong with them, they are eventually going to die.
But everything is killing you, even time.
So at the end of the day, just as he was saying, there is an ethical obligation on all medical health professionals to tell the truth to the patient. But the truth telling, just as you asked, how much can you think that the patient can take? I think will be based on assessment, proper assessment of the patient, and how much, because sometimes you have to take into consideration their educational background, their cultural belief as well, and religious belief, because in our part of the world, religion plays a very important role.
That's what I was coming to. Because if the religious tradition is welcoming of the certainty of death, they tend to take it easier because they know that everybody's going to die anyway. I honestly think that regardless of the person's background, once the person can understand, it's better to disclose.
It's better to disclose, but the timing counts. If at the time you are about disclosing there's something else that's happening to the patient, you can't pour it all at a go. At times there will be a need to calibrate what's happening to the patient. In fact, I'll cite an example. I had a patient who had an ectopic. We took a part of the tube out, we couldn't save it. Then after 4 months, she had another ectopic at the other side, and we were to take that out. So the truth to tell the patient was, actually, we need to take the second part out. You will not be able to conceive on your own, ever. But you will be able to have an IVF because the womb was still intact. This news was broken to the patient in order to obtain consent for the surgery. She broke down emotionally. And the fiancé who was with her at the hospital left her. On hearing that, she will not be able to.
But why did he have to be present for the disclosure?
He was not present when we were disclosing to the lady, but the lady herself passed it on. And I don't understand, I don't know how he understood it. Yes.
So he had to know.
If you say he had to know, well, I may differ.
They're about to get married. That's a fiancé.
Say he's not already married to her. She determined when to tell him. It is her right if she wanted to disclose it right away like she did.
But yeah, if the idea is to get married, shouldn't he know if they will have that ease in having kids?
It's about the timing. One, it is her choice. Yeah. Anytime she can do so. She may choose not to and disclose it later. But at that instant, she disclosed it in our absence. I don't understand. I don't know how the man understood it, but he left.
Because there was nobody to explain that all is not lost.
That all was not lost.
We'll go for a quick break. When we come back, we'll pick it up from right where we are now on the discussion. This is Law Express. Don't go away.
So talking about timing, I also think that the timing for disclosing such information, if it's a terminal issue, is very, very important. Because we had a patient that one time, 1st January, it was a new year. The surgeon came in. He was actually having a gangrenous float, and then we needed to be amputated. Then January 1. The doctor just walked in and said, oh, he was going to discuss amputation with the patient. So I was like, on this first day of a new year, you want to discuss amputation, that you want to cut somebody's leg off with the patient. Then it's timing. It's early the whole year. It's a new year. Everybody is having hope for a whole year. Then you just go that you want to amputate the leg. So he went to the patient, discussed in English with the patient, and then he said, well, the way the foot is, he needs to amputate it and all. The man was calm, and he was just taking in the information. Not knowing he didn't understand the amputation. So we were there, and I was like, so I mentioned the patient name. I'm like, do you understand what the doctor is saying? He said, oh, yeah. He said, oh, he's going to amputate, whatever. And I was like, no, do you understand the amputation? Then he was like, what is it? So I was like, he says they are going to cut off the leg because it's bad, it's dead. And then he just took off the spectacles. He got angry, threw the newspaper that he was reading away, and he was like, what do you mean by that? You want to cut off my leg and all, and you came here 1st January and you are just saying it raw like that. So the timing itself is very, very important.
But it's based on the society. In some places, 1st January is not the new year, so that wouldn't matter that much in that context.
It's very, very important. And then sometimes too, if we forgo jargons and terminologies, then the patient will be able to know the actual implication of whatever that we are telling the patient.
But just to add, there are instances also where withholding terminal information from patients did cause more harm.
Yeah.
In fact, in some instances, they need to also put their house in order. They may want to know, probably it's going to take them 6 months, so that they will know if they've not done it well, if they can put things together. But there was a particular case where the children of a woman who died of cervical cancer sued the doctor. The doctor had warned the lady that I've seen something, come for an examination. 4 occasions, she did not. Eventually, she died.
She didn't know how serious it was.
As if you're one of the children. Actually, on her death, the case took an action, a court action against her. And their basis was, the doctor said, I said it, I told your mom. And they said, you did not say it with enough seriousness. That was the basis for the suit. Of course, it was thrown out, but at least it sent a message to us that at times we need to make such disclosures and be serious with it as it is. Yeah.
Well, then that one, I would think it would depend on the relationship the doctor had with the patient. If it's more of a family doctor, maybe it's a family physician, and so you need to go the extra mile. But if it's a general hospital and the patient comes and you have to ask the person to come in.
Everything I say is serious.
It's serious now. Yeah.
We've talked about confidentiality of patients' data confidentiality in the context of private citizens. Let's look at public personalities. So the celebs, the politicians, all those in the public eye. Could be your community leader, your pastor. How does the medical fraternity look at protection of their medical information, considering that, look, this is a unique situation. There are many people who are stakeholders in their lives.
I will say the Constitution guarantees privacy for every citizen, including public figures, just like it does with private citizens. I will, at this point, draw the distinction between privacy and confidentiality to place it in context.
I want
privacy
to understand
is that
why
right
it has
a person
to take a
has,
patient to
even
tell his doctor not to
exclude all
disclose his or
others
her
from his
his
personal
condition
information,
to family before
personal
that is done.
space, and personal
Yes.
matters. I'm sure that's a patient who wants to be extra cautious. The person has because shared we are still aware of private
information
that sometimes
people are a bit nosy
or professional.
Pick some
it could be a priest. In fact, in this example, it could be a banker.
At a point,
the duty of confidentiality says that
this
to the
information
you've
to go to the pharmacy for a drug.
The gentleman will not disclose it
that
to
he has
third
read the
parties
entire folder
without the
and has
consent
seen the
of
pregnancy
patient,
status or the
unless
and truly
the
the
other
other
lawful exception
is
is
kicking.
kicking.
Yeah.
Very
Like
so
a court order.
And I knew
The court order
what
that
they need to
people did
protect
were not
other
right.
people.
So
But
that's a
how
breach.
they should protect
That
people
was a
from
breach.
harm,
Clear breach.
or other
And
lawful
it had a very
authorities when they
devastating
present
consequence
information
on the way the
now
treatment
talking
of the
about
lady were
public figures,
disappointed.
like we said, they are all entitled to privacy unless they decide to volunteer some of this information
How
out.
about, let me play the devil's advocate. I mean, that's article in the Constitution. It's not absolute and a standalone. There are exceptions.
Yes.
Public interests. So how about that in respect of the data or the information of a public figure?
So basically, just as we have been talking about, confidentiality is a basic right or a basic ethical principle for all health professionals to uphold to their patient, because the patient volunteered the information to them. So whether it's a private one or it's a public one. And more so, since they are public figures, we would expect that there will be much protection of their confidential information as to how much the public may know or want to know about what is happening with them.
Or should know.
Or should know, rather, what is happening with them. But just as you just said that they are public figures, we are interested in what happens with them, their everyday life, or in one way or the other. They have made us interested in their lives. And therefore, if something is happening to them, we have to also be interested in what is happening and contribute anyhow or any way that we also deem fit. But then it's still their rights, and health professionals are still bound by the ethical principles of confidentiality to safeguard their information from them. Because just as the American case of Naomi Campbell, at the end of the day, the court said she's a public figure. You are interested in knowing what is happening with her drug addiction, but it doesn't mean that it is your right to be able to publish anything about her because she's public, and therefore her face is out there and you can publish anything about her. So they are also entitled, and their privacy and confidentiality is also guaranteed.
Where do we draw the line? Yes, we have a vested interest. We need to know because you are in the public light, and the curiosity of it, if for nothing at all. For instance, if you're a government official and your treatment probably is going to be drawn from state resources, shouldn't citizens want to know? Shouldn't they care enough to, probably if it's just for the empathy bit?
In fact, there's a distinction between what is in the public interest and what is interesting to the public. So we then look at, let's go back to the Naomi Campbell case, and their lordships were clear that the mere fact that it was about somebody's health should be treated ab initio as private and confidential, unless she decides to volunteer that. Because in that case, if they had exposed her attendance of that Alcohol Anonymous meeting, it would have discouraged her. This was somebody struggling to get out of the addiction. It may detract her from, continuing. So the issue of public figures has to be tackled with some sensitivity. In fact, it happens in two instances. I think, in the first place, the Constitution says these public figures should be people of sound mind. It does not go further beyond that. But taking it from the angle of being an employment. Because I remember the previous president once said sometimes they stay all night. Sometimes if you look at the campaign they do, you look at John Mahama, the stress, you need to have some stamina to be able to do so. So taking it from the employment angle, then I think we should be able to have a declaration of fitness for them. And the practical difficulties with that would be who will be able to bear the cat. Because at the flag bearership level, it will be difficult as to the neutral body to declare that this one is fit and that one is unfit. But I think at the party level, when they are doing the flag bearership slot, there they can have their own means of assessing their candidates.
Suggesting policy
to declare fitness.
But at the heart of it all, okay, from where I sit, what you should ask yourself as a nosy person is, these people are still human beings, regardless of whether they are celebs, people in the public light and all of that. If this was your relative, would you be comfortable if their medical condition was conversation in the public space?
In fact, that's an interesting question you've asked. Somebody published a book about the cancer struggle of a former French president, Francois Mitterrand. And it was deemed by the Medical Council in France as a breach of confidentiality. He was fined, he was disbanded. That was a doctor, his personal doctor was the one who did that. The book was banned, the man himself was disbarred from practicing medicine, and the book was stopped, injuncted from coming out by the estate of the president, and it went really far. So like you said, you do not need to embarrass. People are interested, but it should be with the right cause, unless there are lawful exceptions for breaching confidentiality.
Of course, sure but before we get there, we sampled people's opinion on our discussion today.
Wow.
Let's take a listen.
I feel as a doctor, I should tell my patients literally everything they are going through into details, because some people do not really see the extent at which they are sick until you tell them what exactly they are going through. So that would help them to take their medicines on time and then do what they are supposed to do to get well.
No, doctors shouldn't tell a patient everything about their condition, because I feel if they do, they could feel bad. But if it's very critical, you could actually involve a third party and you let them be aware of their condition.
In my personal view, I think a doctor can bring in a third party when the situation or the sickness of the patient is critical. Because when the doctor tells the patient directly, he or she can even die. But when a third party, which is a sibling or maybe a close friend or someone closer to the sick person, tells him or her, he or she might feel a bit comfortable with it, even though it's not easy. But I think a third party would help.
Okay, from the views of the people that we just watched, let me take it from the last person. Talking about even they be able to, medical personnel giving the information to third parties so that they will be in a better fit position to disclose it to their relations. I feel maybe they are thinking that from the perspective of the medical personnel, they will just be blunt and not add any affection or anything to the situation on the ground. So they are thinking is that a relative will be able to sugarcoat it and tell the person in a better way, so as for the person not to be able to feel bad.
Just manage the shocks of it.
Yeah, but from the very first lady who responded also, she was saying that if we are able to tell them the truth and be frank and blunt with them, at the end of the day, they will know the severity of their condition and they will be able to adhere to medication and all that. So it's in two ways, but at the end of the day, the duty on medical personnel is to hold confidential information of the patient. It's not in our place to disclose it to third parties, unless the third party is somebody that the patient, him or herself, has appointed. That for this one, you can tell the person, because the person is the one going to help me. Maybe that's the person that is helping me at home. So if the person knows what is actually wrong with me and the severity of it, he will be able to give proper care to me in the house, or maybe financially or anything. But without the patient express consent, it's not in the place of any care personnel to disclose patient information to third parties.
I largely agree to a lot of the comments made, except to add that it can be all the information. There's a need for some sensitivity and graduation of the information that
so
material.
If you want to amputate, you say, oh, we'll take your toe, then we'll take the other toe, until you get all the way to the knee. Is that a graduation?
Not in that sense, but to tell the patient, I'm going to cut your leg, they will panic a bit. There are ways of going about that so that they appreciate what needs to be done.
So how would you do this? So would you rather say, I'll take your leg, then the next time I would chip off your leg? Like, how are you supposed to graduate? This information is as hard as it can be. And there's no way you can sugarcoat this or cushion it, no matter how you do it.
In the clinical setting, there are ways we go about this without being too blunt, but meaning the same thing and allowing them time to process it. We counsel them, we let them understand the necessity for that, and if we don't, what could happen? There is a case where the person thinks, I'm a chief. If I die without this leg, I can't even qualify as a proper ancestor. Some have those cultural instincts to bring in. So they prefer to die with that. And on the note of the principle of autonomy, you need to respect that. But our duty is to explain the consequences, the options, and what can be done. But so long as the patient is competent, is mentally fine, understands all that, and decides that that's my decision, we will respect that.
Graduating it too can mean that you are giving options to the patient. So the example of amputation that you gave, the amputation will be the best option because maybe life expectancy out of the amputation may be 50%, 60%, 80%. But then there's an option for antibiotic, which will maybe give you life expectancy of 15%, 20%. For the patient to sit back and make that decision for themselves, but not necessarily for you to go that the only way is for me to amputate. Without the amputation, you are going to die. Give off all the information, let the patient sit back and make their own decision out of it. And when it happens that way, the patients are able to own the information, the decision that they make, and giving consent for the amputation, because definitely from the beginning, maybe the antibiotic would have started already. Yeah. And you let the patient know that, well, we started, but then looking at how it's progressing and how whatever that is happening is not going to help. So let's go to the ultimate one. And from there, you'll be able to get better consent and cooperation from the patient.
We'll go for a quick break. When we come back, we'll take the conversation up from the point of bypassing disclosure. Under what circumstances can you just ignore all the noise and go straight to the business of the day? This is Law Express. Stay tuned.
So the duty of confidentiality is also not absolute, and there are bases, justifiable bases sometimes for breaking that. And at times we do so to protect other people, to protect third parties in the interest of the public, to prevent harm. I will cite the case of the Tarasov versus the Regents of University of California, where a gentleman made advances on a lady. He was not successful. He became depressed and told his psychiatrist that he would kill the lady. There, the psychiatrist thought it was a confidential information, so he would not breach it. So he did not disclose this to the lady or their family. After a while, the gentleman got close to the lady and the family, befriended the brother, and by getting close to them, he was able to assess how to get access to the lady. Within a month of making that threat, he killed the lady. Tatiana Tarasov was killed. And the family sued that when the gentleman made that threat, they should have notified the family. So it was one of the justifiable bases, so that you make a disclosure that this is the intention of this gentleman, so the adequate caution can be taken.
So you're looking at criminal conduct.
Potential criminal conduct to cause harm to other people. It's a justifiable basis for breaching that. Also, when it is a request of the court or any lawful authority, if the Nurses and Midwifery Council invites you that as part of their proceedings, you should disclose what happened regarding a patient as part of proceedings, it's a justifiable basis to also breach confidentiality. Then there was a matter, that's the other side of this, a matter where a doctor attended to a man who had done hit and run. He hit somebody on the road and ran away, but he got injured and therefore sought treatment. The police tracked him to the hospital and asked the doctor, give us the identity of the gentleman you just treated, because he had committed a crime and we need to track him. Then the doctor invoked this duty of confidentiality, that because of the ethical requirement, he can't disclose. The doctor was jailed, actually. He was found guilty of obstructing justice because it was a lawful disclosure, and his refusal to do so was deemed, unacceptable and also against the law.
Let's look at it from this perspective. Assuming you were at a hospital right now and somebody showed up with a gunshot wound, what is the first course of action? Because we know that guns are not like knives, kitchen knives, that people can just hold around. And perhaps he doesn't have a police report or any form for medical treatment from the police. What is the first thing a doctor is supposed to do?
The first duty of a doctor is to save lives. So their focus and attention will be to stabilize the patient, save life, and then afterwards we can inform the police to do some investigation on this. And when the police come in, that will be a lawful request, and that one confidentiality can be broken. We, under Section 1978 of Act 29, by way of our office, the special position we hold in the hospitals, we are also supposed to act to protect and prevent crime. But I'll cite something interesting that happened at Confidentiality years back to you. Something happened in the community where a policewoman prevented some soldiers who were trying to shoot a certain popular pastor. That was in the era of the junta. Later, the policewoman was carried to Confidentiality to receive care. While there, some military part of the junta people came to Confidentiality to look for the policewoman, actually to retaliate. What happened? The doctors told me they were able to resist, that they won't show where the woman is admitted to or where her bed was. And they were invoking the principles of confidentiality. But in the end, the soldiers moved in, they were looking for her. Finally, they found her. And I must say that marks one of the darkest eras of our healthcare. They shot the woman in her bed, right there.
At the hospital?
At the hospital, Confidentiality Hospital, Confidentiality Teaching Hospital. But I raised it to support the fact that the doctors at least did their ethical duty of resisting showing them where the woman was on grounds of confidentiality. So even when a gun was pointing to their heads, they managed to resist that. But today, some healthcare personnel are unable to resist.
They are actually even on radio discussing people's conditions.
Not because a gun is pointed at their head, but sometimes because a phone and data is pointing at them, and we are able to release the information like that.
It's an exception to the rule, so if it's in the public interest or public safety, then you necessarily need to reveal it. So if you take the case, maybe in a situation where there is an HIV patient at your facility, you have counseled the patient enough to be able to disclose to someone else, because for HIV treatment, mostly they will want a third party to it so that the person can monitor your treatment and make sure that you are taking the medication and all. But then the person has refused all this one and says he or she doesn't want anybody to know. But you're also in the community and you find out that the person is living a reckless life. Say the person is saying, well, definitely somebody infested me, so I'm also spreading it and all. It is still not in your position as a healthcare provider
to go to radio,
to go and just spread the news that as for this person is HIV positive, and so be careful of the person. That's why we have laid down. So for every district or every municipality, there are health directorates there. So it will be with you, it will be in your position to report same to the health directories for them to take it from there. They have their procedures and then their ways of reaching out to the person and getting the person to whether stop or prevent the person from spreading it to others.
We
And that
have
one will be in public interest. That's how come you went to disclose.
We have a few questions coming in by way of social media. Let's try to answer them.
Hello, Noella. My name is Wilson. I went to a nearby clinic recently, and it turns out that one of my neighbors works there. Not long after, I found out that people in my area knew about my condition. I'm really upset. Isn't my medical information supposed to be private? What rights do I have in a situation like this? And can I take any action?
Obviously, it appears his right to confidentiality
has been breached
somehow. First, we may need to verify, but let's assume that truly that's what has happened. Yes, it's similar to a case of a nurse who was found to be HIV positive, and at a point he realized that his colleagues within the hospital had an idea or they knew. In that case, he can sue. He can sue. If he's able to identify the person responsible for the breach, he can report the person to the Medical and Dental Council. They will take it from there with sanctions. If it was a nurses, it can report it to the Nurse and Midwifery Council as well. There are other cases that may call for even an injunction. I'm sure we'll get there to some of the interesting cases on breaches. At times, injunction can be done where it is too late to injunct, a normal suit can be brought for damages.
Yeah, but there's nothing that points to the fact that it is that woman who leaked that information. Exactly. So that has to be, of course, ascertained,
have to be verified. Exactly.
Because, yeah, she lives there, but what if it's just a coincidence?
You also have to know if that's the only hospital or clinic he has ever attended. Because maybe
with that condition.
With that condition, exactly. Maybe you had gone somewhere else, and it just happened that when you got here, your neighbor was also there, and you heard about your condition after visiting this very clinic. It doesn't necessarily mean that the information came from the last clinic that you went to.
So he needs to establish what the chain of information was and then figure out where the breach occurred, if at all, because it could have even been from him.
That's true.
My name is Mausi, watching from home. I noticed that some private hospitals now ask you to fill out your personal and medical information on tablets or online forms. It makes me wonder how safe that information is. Can hospitals share it with third parties? And what happens if there's a data breach?
For medical records, when we were talking, I mentioned that now it's mostly paperless transactions that we
Everybody's migrating into the new world.
And therefore, the server itself may not be owned by the health facility. But then at the end of the day, the Ministry of Health has a policy on medical records, which was formulated in 2017. And then it gives a list or gives a holistic view how medical records should be kept and all. And then the exceptions to your keeping of medical records or how patient can even access it. Yeah. Because for that policy came before Elizabeth Barr, but it wasn't, I don't know whether it didn't come to their knowledge whatsoever, because for the policy, it even makes exceptions that if a patient needs the records to build up a defense in court, you must necessarily give the records to the patient. But aside that, they make guidelines as to how we should store the information that is generated electronically or even
manually,
hard copy and all. So it's a whole document on its own, medical records policy from the Ministry of Health that guides health facilities as to how to save and then secure medical information obtained from patients. So I think the fact that we are doing it online does not necessarily mean that third parties will have access to your medical record. And it's safe, just as the manual one.
That is if you follow
the
requirements, the guidelines for protection of data.
It is safe.
Because there's a Data Protection Act in this country, which also sets out what anybody who collects, processes, stores data must do. And these health facilities are collecting and processing data.
Personal data.
So once that is in place, you need to follow the laws. Yes. But off the top of my head, if you you need to make sure that as an institution, you keep the data secure by going for the most safe and secure data facilities or servers, whatever you want to call it. Even within the hospital setting, the people in charge of records, do they have passwords? How often do they change them? Is there a unique password for everybody to ensure that there is that responsibility? Then, of course, you need to use the data that cannot identify people easily whenever possible. So you can have a system where you do not key my name in and everything drops at once to just anybody, but there are layers in respect of access, of course.
That is true. So per the Data Protection Act, you, the facility collecting this information, have a duty to ensure that they are protected, and they will take responsibility when not. So the gentleman should be rest assured that the collection merely does not mean there's going to be a breach, but should there be a breach, yes, he can take them on. And then I must also add, and this is to the health facilities, that according to one cases party, Info Solutions, if you release the information, if you are to release the information, you need the consent of the person,
yes,
in order to come out with that. One way, however, if it's becoming impossible probably to reach the person for that kind of consent, according to this particular case,
you take out
their names or anything that can make it easy to identify them.
You see, when that question, okay, talks about a data breach, but it doesn't indicate whether this data breach will be intentional or accidental. And these are two aspects we need to look at. Where somebody hacks in, that is accidental. I mean, but where you now put together this data and give it to a pharmaceutical entity, that is intentional. We'll go for a break, and when we come back, we can have that conversation.
So the breach of information, as you asked, yes, could be negligent.
Exactly.
And negligence may not matter whether it was intentional or not, just that in negligence there's a need to establish that they did not exercise reasonable care as was due. So if it was a hacker with some superior skills that was able to bypass the existing
in a way
firewalls,
that you could not have
that
expected,
they couldn't have, and you acted reasonably before and after, then that one, you are not likely to be found negligent. Yeah.
And just as I said, it's not, most of the health facilities are not the people who developed the service or who are in control of the service, which supply the internet for the e-services that they are providing. So if the hacking or maybe the breach came from the server side, and the health facility is able to establish the fact that it wasn't from their end and was from that side, then probably even if the person sues, then they will be able to insulate themselves from damages.
I mean, we know data is money. There are still some recalcitrant people who would see this opportunity, download all this and sell to people who need that for their own research, processing, whatever they need it for. And when this happens, this is a clear breach. And if you are aware that your data is out in that manner, you can take the necessary action. For instance, you have a new cell phone, you go to a hospital, you go through registration, and after records, the first thing you get is an advert sent to your phone by text telling you where you can access health insurance. I mean, what are the odds that this health insurance entity just figured out your number out of the blue on that particular day? There is that connection, right? And automatically you would know that there's some breach somewhere. So in instances like this, yeah, you have the option to take certain legal steps to ensure that the breach is stopped, and probably you can get some damages for that breach. It's been an interesting conversation, and especially because you are all dual practitioners as lawyers and medical personnel. We clearly did not exhaust our conversation. We could explore having a second part of this discussion on patient confidentiality. Viewers, we were joined by Elizabeth Owusua, and Dr. Edward Ado Dankwa. My name is Noella Seydu. This has been Law Express. Till same time next time. Bye.